Hey, I'm Paul Rabelais. I'm an estate planning attorney, and in this video, we're going to talk about the 8th of 8 parts on how to leave it to the kids. Okay, finally got here, the last one. This is an important one though. This is the kind of wait till your spouse dies before your children get it scenario. And so let me jump into it. What I'm going to do is I'm going to give you 2 ways to leave it to your kids in this one video. So, you get an extra one for free. All right, so the first one is really applicable to folks who live in the state where I am, Louisiana. Not really applicable to people in other states. The second one applies to everybody. So the first one I'm going to talk about is where you leave your kids what's called naked ownership, subject to a usufruct. And then the second one that I'm going to talk about is where you leave assets in trust and name your child as a principal beneficiary, but you name someone else, perhaps your spouse, as the income beneficiary. So in general, in both of those circumstances, when you die, your children aren't going to get anything right then. They've got to wait out until your surviving spouse or that person that you designated to get certain rights dies. Okay, so the reason parents do that is they want to provide and let's just call it for their spouse, because it doesn't have to be the spouse, but it typically is. A parent often wants to make sure the spouse is provided for with resources, and then provide for the children after the spouse passes away, whether that spouse is the parent of your children or not. So first thing we're going to talk about is the naked ownership. It's a Louisiana term. It is very common in Louisiana, but if you're in another state, the lawyers there will have never heard of it and won't want any part of it. So the reason it's so common in Louisiana is because in our rules, when a married person dies, if they have no will, no trust, no nothing, they've done no estate legal planning, then our default rules, or often called intestate rules, require that as to the deceased spouse's half of community property, their surviving spouse will inherit this usufruct until the surviving spouse dies or remarries. And then those children of the first spouse to die, those naked owners, become the owners when that usufruct ends. So more on that later. Okay, so let me start with this. When you leave naked ownership to a child, you're going to be leaving your spouse or someone, but typically a spouse, the usufruct of your estate or those assets that you leave your children naked owner of. Usufruct, nobody knows how to say that word, but when I hear most people explain it, they typically say something like, I'm leaving my spouse the usufruct, which means my spouse has the right to use and receive the fruits from those assets over which he or she has the usufruct. And then in every usufruct, there's a term. How long will your spouse's usufruct last? Will it last till your spouse dies? Will it last till the earlier to occur of your spouse dies or remarries? And in some cases, it might say your spouse's usufruct terminates when they die, remarry, or live with somebody, shack up, not necessarily in those terms. So those are some scenarios. And then that surviving spouse's usufruct terminates and the assets revert back to the naked owners, who then become the full owners. Now, there is a lot of law on what are the rights and obligations of the usufructuary and the naked owner. And those rights and obligations can depend on whether you leave your child the naked ownership of money, real estate, shares of stock, vehicles, or some other class of asset. But in general, when you leave your child naked ownership subject to your spouse's usufruct, your child's got to just kind of sit around and wait for that usufructuary to pass away or for that usufruct term to end. And there's not a whole lot that your child can do. Yes, in some extreme cases, when the circumstances warrant it, sometimes the usufructuary has to post a bond to protect the interest of the naked owners. And yes, in some extreme cases, there could be an early termination of the usufruct, but in general, naked owners got to sit around and wait. And so that's one form of leaving it to your children in naked ownership, subject to your spouse or someone's usufruct for a term. The second one I'm going to go over is, and really applicable nationwide and perhaps even in other countries as well, is where when you pass away, you leave things to a trust and you name your child or children as a principal beneficiary or principal beneficiaries of that trust. Now, when you leave it to a trust, you're also going to name what's called an income beneficiary, often your spouse. And oftentimes that income beneficiary's interest will last for the income beneficiary's lifetime. So after you die, your assets go into a trust. Your spouse gets the income off of those assets for the rest of their lifetime, if that's the way it's set up. And perhaps the trust even stipulates that if the income beneficiary, your spouse, needs to use some of the principal for their typical standards of health, education, maintenance, and support, then the surviving spouse can dip into the principal, or the trustee can dip into the principal on behalf of that surviving spouse. So that role of trustee becomes important. So, and then when the income beneficiary dies, then all of the trust assets then go to the principal beneficiaries. So you might start to see where those are common, but there's a key difference. I want to go over that. And I'm going to give you an example. Let's say dad has $100,000 of cash, or say money in the bank, and he dies and he leaves his wife the usufruct of that $100,000 of cash, and he names his two children as the naked owners of that cash. Well, now what happens with the surviving spouse having the naked ownership of that cash? Our law says she becomes the owner of that cash with an obligation to to pay that amount to the naked owners at the termination of the usufruct. So what that means is she does whatever she wants to with the $100,000. She goes and buys stuff, she spends it. It's hers to do what she wants to with. But her estate has this debt, so that when she dies, her estate owes his children $100,000 or $50,000 apiece. Now, if there's no money in her estate, there's nothing for the children to get, or if it's that money had been invested and grows significantly, the naked owners are due that $100,000, that amount of the usufruct at the time that he died, at least for cash and for other what's called consumable items. And I've done other videos on rights and obligations of usufructuaries and naked owners. You can search YouTube for that. A little bit different with when you leave $100,000 in cash into a trust, name your spouse as the income beneficiary, name your two children as the principal beneficiaries. So that money, maybe it goes into a savings account, maybe it's invested, who knows. But your spouse is going to get the income, the interest, the income, the dividends that are produced. And if the trust says that a trustee can make distributions to the income beneficiary for the income beneficiary's health, education, maintenance, and support, then they may dip into that principal. And let's say when the income beneficiary dies, there's only $60,000 in the trust because the income beneficiary, your spouse, used some of that principal for their needs. There's only $60,000 left when the income beneficiary dies. Well, when you leave it to a trust like that, the children will get the $60,000 remaining in the trust, $30,000 apiece. There's no debt like there is with the usufruct for the amount that was originally there when the husband passed away. All right, so the summary of this: wait till the spouse dies, inheritance to your kids. And oh, by the way, make sure you click on the subscribe button and then hit the notification bell. Really trying to grow my subscriber list. Apparently, what YouTube tells me is the more subscribers I have, the more people they send these videos to and give them an opportunity to review it. So trying to educate as many people as we can. Hit the subscribe button and the notification bell, then give it a thumbs up like. So you can, bottom line on this one, this 8th of 8 parts, you can include your children in your estate planning program but you can also include them in a way that you're providing for some other individual, perhaps your spouse, first, so that your children really don't inherit from you until after that other person, your spouse, passes away. But when you pass away, your children are inheriting rights to get certain assets when your spouse passes away. So that's the leaving your children naked ownership, subject to a usufruct, Louisiana version. And that's the leaving assets to a trust, naming your children as principal beneficiaries, subject to your spouse perhaps having this income beneficiary interest for life, with the opportunity to use principal for needs that they have. Okay, now I can take a deep breath. I've finished my 8 of 8 parts. It's been exciting. I've seen the numbers grow. I've seen the comments and questions come in, all really good stuff. Keep them coming, by the way. Really excited about moving on. This was 8 consecutive days. I don't think I've done 8 consecutive days of videoing, but more I do, the more content comes in my mind, and I'm going to keep, going at it. So stay tuned. A lot more to come. Post your questions and comments in the comments below. I'm Paul Rabelais. Y'all have a great day.